Cacao. Welcome back. The Democratic Alliance says it will reconsider its participation in the GNU if it continues to be treated as a bystander by the ANC. The DA has been left disgruntled by the signing of the Land Expropriation Bill into law. The party claims that the bill was signed into law despite a legal opinion from its minister, Dean McPherson. The DA's federal executive member, Cacao, joins me now in studio. Karabo, thank you so much for making time for us. Good evening.
Good evening, Abuti. Thank you for having me here.
Are you staying or are you prepared to leave this GNU as the DA?
We're 100% prepared to leave. But for now, we are staying, and for one reason. We care about South Africa. We're very aware of the fact that in the past 30 years, life has been a mess for South Africans. People are unemployed. People are poor. People are unable to put food on the table. And it is because of those reasons that we took the decision to enter a government of national unity, to dial down the mess that we've seen in the last 30 years and positively contribute towards changing the lives of South Africans. And that's why we're pleading with the president to say, look, the last 7 months have actually been nicer than what we've had in the last 30 years for South Africans. We've seen the green shoots of the economy, the rand reacting positively to the GNU, and we have an opportunity here to turn things around if we are able to successfully sit around the same table, find each other and roll out what is the order of government, which is to attend to the needs of South Africans, and that's what we want to do. Yeah, so
you're not suggesting that a lot has been achieved in the last 7 months than what's been achieved in the last 30 years, are you?
No, that's not what I'm saying.
Okay, it's been nicer.
Okay.
Just want to make sure. You said as the DA that you will not be taken for granted. And as I said in my intro, what's confusing me is that there have always been these red lines. And yet today you said there are specific red lines, like when the ANC crosses that red line, as the DA you're going to leave. But when the president was constituting cabinet, you had your own expectations about how many posts you must get. And there was a threat. I remember the letter that John Steenhuisen has written, the one Helen Zille also wrote to Fikile Mbalula, and the threat was we have to have these positions or else. It happened again with the signing of the Bella Act. As the day you said, that's a red line. What happened in Tshwane was a red line. Now it's the expropriation bill. It happened with the NHI. How many red lines do you actually need for you to just walk away?
So here's what you need to understand. Firstly, let's start with the position sharing. We were very much aware of the fact that the ANC, yes, is not a majority, but it holds majority of the seats within the coalition. And so we are not in a position to get everything that we want, but would rather have a seat on the table to positively impact the lives of South Africans than have no seat at all. So that was the modus operandi in that decision making. With the Bella Act, we made it very clear that we didn't have a problem with the whole entire act, and that's why we were specifically making reference to clauses 4 and 5, and that's what we wanted to challenge. The compromise we made in the best interest of South Africans was saying, yes, we didn't want this act, but at least our minister, a DA minister with a sober head, is now responsible for regulations around how we're going to enact this, and she has taken it upon herself to make sure that these regulations are going to be ready along the year. And so far, schooling has been running well as far as the impact of the Bella is concerned. We are here now where we find ourselves with the Expropriation Act. Again there, since the inception of the conversation of the land, of land in South Africa, the DA has always been pro Section 25 of the Constitution. In fact, we've always even given examples of in cases where we've successfully been able to roll out that section. For example, in the Western Cape, we have an 84% success rate of land reform cases in the DA-governed Western Cape. So that has never been a problem. The issue was that the state has been lazy. But now we have an act, and our contestation even there again is not its entirety. It's the fact that the process to be followed when there are disputes has two clauses that are in direct contradiction of each other, which makes it unconstitutional. And what we are saying to the president, because the DA is, we firmly believe in ethical leadership, Clement, and this is something that we want South Africans to understand. We cannot, in good faith, knowing that we've received legal advice that says that act that Minister McPherson is supposed to oversee is unconstitutional, sit back and be like silent about it. And that's why we've written to the president to say, yes, we are aware that it was passed in the previous administration, but we have a new administration, and this administration has a responsibility to correct the mistakes of the past.
That was legal advice from Dean McPherson. You also can't bully the president to take an advice of your minister. When the bill is in front of the president, my understanding is that his constitutional obligation is he's got to sign it, unless there are constitutional concerns. He must send it back to Parliament.
Yes, and that's the advice
from Dean McPherson is not the only advice the president gets. What I'm getting from the DA is, oh, just take the advice that comes from our minister. Why can't you trust the president that you, as the DA, elected into power, to make a decision? He's taken Dean's advice as a minister. He's taken the advice of other ministers, and he says, I'm satisfied that this passes constitutional muster, but you still cry foul because you want your advice to be the one that's more prioritized.
No, we want our advice to be taken, not just prioritized because we are crybabies who want to throw.
It's been considered.
No, but listen, Clement. The problem here is, yes, the president has other legal advice, and yes, we voted him into his seat, but we do so very much aware of the fact that he's not the best president this country has had. We ourselves have criticized his leadership. We ourselves have said that we don't have 100% faith all the time in the political party that deploys him. And so it would be disingenuous of us to now suddenly wake up and say, yes, we are in this marriage for the sake of the kids together to save South Africa.
Which is never healthy, by the way.
Yeah, but the bottom line is South Africa is in safer hands with the Democratic Alliance and government than with us out of it. It's better for us to be there and to play our part. And we've seen how the part that we've played in ministries, for example, like the Ministry of Home Affairs, that we actually get to work and get things done. We've been able to clear backlogs of applications.
Yeah, which is a process also that was started by the previous administration.
I hear you,
right?
But it was fast-tracked by the work that is being done by Schreiber. But I want to go back to the question of the legal advice of the president, because that's very important. The president would have not lost anything at all had he just sent the bill back to Parliament. Because that's what we were asking. We're not saying throw it out. He has an obligation yet to sign, but if there is a proper problem, particularly given that he's not alone in government anymore, you need to be able to, given the statement of intent that you've signed, be able to consult your coalition partners. Your biggest coalition partner, that is being the Democratic Alliance, is saying to you they're not happy with the decision you're making. And we're not the only ones. We have other coalition partners who are also saying that they're not happy. That must be able to at least nudge your conscience in the right direction. The contestation here, again, I want to stress, if we as the Democratic Alliance are earnestly saying to South Africans we believe in evidence-based decision-making, one, two, that we believe in ethical leaderships for the best interest of South Africans, then we did right by saying to the president, we don't believe this.
You want him to act illegally, Karabo. Let me tell you why.
Okay.
The president is not obliged to consult with anybody once the bill is in front of him, because that's a parliamentary process. What he can do is take the advice of the minister in charge of that portfolio. He can take advice of course, some of his advisors, because he needs to make sure this passes constitutional muster. You are saying to the president, yes, there's a parliamentary process that is done. This was voted in Parliament and supported. Actually, no. you take it back, even when the president says, I'm satisfied with the constitutionality.
No, and there's
of the bill.
nothing, first of all, we're not saying he must do anything illegal, because him taking it back to Parliament is well within his powers to do. So there's nothing illegal there. So that's a misconception that you're creating here.
No, what I say is illegal is you want him to go speak to other political parties.
No, but
that's not what the Constitution requires.
This is how then you don't understand the dynamics of how coalition governments work.
But that doesn't supersede the Constitution.
No, and that's
even
exactly,
your statement of intent. That's not a legal
But that's
document.
exactly why we're saying to him, if we are of the opinion that there's a constitutional problem, that the act does not meet constitutional muster, then we need to review it. In actual fact, he could have even saved himself to say, given that people are going to court over this act, as a president who has an ethical mind, who wants to roll out a mandate that is safe for all South Africans constitutionally, I'll wait until the review comes. I'll wait until we get a full constitutional refute. Because
He's satisfied.
No, Clement,
and your opinion is not supreme.
Listen, the Constitution's opinion is supreme.
Yes, and he says
that is why. But you honestly, Clement, what the argument you are making here seeks to suggest that just because he himself has belief that in his team,
yes,
that he should lead with the advice of his team all the time.
No, not all the time.
No, but he must lead with it.
He's considered all the advice, including yours,
but you're saying
and it's decided to say, I'm signing it. Why can't you accept
Clement,
that?
You are saying here, because the president's advice he trusts, because he's always had it before, he must move with it. And that if anybody else seeks to challenge that advice, that they should do so not wanting to persuade a different outcome. And the reason why I would even implore on you to think differently about this is because the same leadership team that he has consulted in the past is the same as the team that we've had of his entire presidency. And we've seen that that hasn't always yielded good benefit for South Africans. But what we want to see and to be rest assured of is that there is no confusion at all on the arbitration process within the Act, on when cases of dispute exist within the process of expropriation. And we also want to deal with the problem of the onus that lies within individuals to seek the counsel of the court.
Let me ask you this then, because my understanding is that the Act is actually more symbolic than anything else. It's not really going to change much. I think when you look at it, it merely aligns with the country's expropriation laws, with the Constitution. But then as the DA, I feel, and let me know if you hold a different view, I think you are fear-mongerers sometimes, because you're trying to make South Africans feel like, oh, my property is about to be gone, which is not really the case. But it's the fear-mongering that I sometimes associate with the organization. What exactly is your concern? Because this bill just aligns with what is in the Constitution, Section 25.
I hear where you're coming from. We're not trying to fearmonger here, because like I said in the beginning of this conversation, Clement, that we have always been in support of Section 25 of the Constitution. And that is why I even said to you, it's not the whole Act that's an issue. It's just a minor contradiction of a clause versus a clause. Fix that, we move.
What's your contradiction concern?
So the contradiction is, the one section of, there's one clause that seeks to, of the two clauses, the contradiction that exists deals with the role that the courts play here, right? Whether you seek whether you seek the counsel of the court ahead of time or towards the end when there's a dispute here. And the second thing that we also have a problem with the Act is, again, like I pointed out, the onus that rests on the shoulders of individuals who are facing dispute to seek the counsel of the court at their cost, irrespective of in which side of the table they sit on the negotiating table. But I also want to move us forward to another thing that is a red line here, that is NHI. When we campaigned to South Africans, we made it very clear that, one, yes, we want universal health care for all South Africans. Universal health care, however, does not do away with medical aids and health insurance for South Africans. Universal health care does not subject South Africans to no choice on where they get their health care from. Universal health care does not subject South Africans to a process where they need to pay heavier tax to fund something that its model is shady.
You've already raised those concerns, Karabu, during the parliamentary process. Remember the public hearings?
Yes.
As the DA, you raised those concerns.
Yes.
You've lost a political fight in Parliament. You have to accept that.
So, but look, here's the thing then if we ourselves as the DA say we truly care about South Africans and we want to make sure that people have the best healthcare possible and that the country itself is able to fiscally be in a position to roll out sober legislation, then we must be able to not back down from the fight, because the backing down from the fight means we were just talking about it politically.
And nobody
and it was
says you
just
must back down
politics.
from. Let me explain what I mean.
Okay.
You need to understand that there's a parliamentary process that unfolds. I mean, the NHI is over 10 years, where Parliament, which includes your members, went to different provinces, canvassed views from medical aides, from political parties, and then Parliament constitutionally decided we are passing this bill.
Yes.
It sits on the president's desk. The president decides to sign it. You can very well take it to court, but as the DA, you are coming to complain to the president in the ANC as if these bills are only passed now. These bills were passed constitutionally before you arrived here. So what exactly do you expect this GNU to do?
So political parties, interest groups, and even ordinary South Africans always have the right and even the responsibility to challenge any law that they do not feel serves their best interests. You can do that in court. Yes.
But you guys are trying to fight in the GNU and invoking Clause 90.
But because we are in government too, the political fight can't happen outside of the political arena. When we are in this administration, although the laws were passed in the previous administration, given that it is this administration's responsibility to roll it out, we too bear the responsibility of the government's order of business. And it is on the basis of that responsibility that we would want to lobby the president against some legislation or acts that needs to be signed into law. Particularly because what you would also agree with, Clement, is yes, if bills were passed if whatever bill is passed in a previous administration is binding for the next. But what is also true is that the next administration bears the responsibility of review and revoke. And so you can't just say, just because it has been done in the past, we must move forward. If that was true, then there wouldn't even be a parliament to exist to begin with, and a process of there being constitutional amendments if that's the case. We wouldn't even find ourselves in a case where we are looking at reimagining things. We need to be able to keep up with the times. Ideally, Clement, if the South African government in the past 30 years, the ANC government, was able to make sure that when Bonkgono le Bontatemoholo go to clinics, they can find proper medication instead of paracetamol. If they could have made sure that clinics and public hospitals are of good quality, if they could have good quality infrastructure and maintenance being at the heart of the operation there.
We wouldn't
if they, Clement, were able to recruit more doctors into this country instead of chasing them away, as is going to be the case with the NHI, perhaps would have extra faith in the ANC to roll out the NHI. I agree with you, and listen, I don't hold anything for the ANC. I think they've really fundamentally failed when it comes to public health. But I also criticize you as the DA that you're trying to muddy the waters here, because there's a separation of powers. There's a parliament that does its work. There's the executive that does its work. Parliament has done its work. The executive must do their work. And I'm not saying you must not lobby the president, but I'm just saying understand that Parliament has done its work. The president's bills are in front of him. He signs them as long as he's satisfied that they pass constitutional muster. As the DA, rather go to court, go challenge it in court, as opposed to try and want to strong arm the president to somehow return the bill to Parliament when he himself is satisfied that it passes constitutional muster. And Parliament, in its majority, because this is a democracy, Parliament in its majority passed the bill. I hear you. And let me give you two examples, right? One, let's go back to Bella and the process there. It was the previous administration that passed Bella. But it was this administration that went through the NETLEC process and it was in this administration that President Ramaphosa was able to look back at ways around what was in the previous administration passed by a majority government and find a different way of rolling it out. And so he can still do that with the Expropriation Act. He can still do that with the NHI.
I mean, nothing has changed with the Bella Act.
But also, hear me out, Clement. The
but you know nothing has
responsibility-
changed with the Bella Act.
Yes, and that's what we know, that nothing has changed.
Yeah.
The only addition there is that we have the power of the regulations. We are aware of that. And that's why we have said, because we understand that we are in a government where compromise is necessary,
Yeah.
and we are of the opinion that it meets the best interests of South Africans, we will compromise. We right now are not of the opinion that that is the case. We still want to serve the best interests of South Africans. We still want to be in the GNU, to grow the economy, to create jobs and alleviate poverty.
All right, Karabo, I'm out of time. Thank you so much for making time for us. I really appreciate it. That's Karabo Kakao, who's the DA Federal Executive Member.
Life of an artist, bacho xa spices, glorifying drugs as a stage fright cure. You can try this just when you're about to grab your chance of staging. Excitement, you can't think out this industry, or should I say this killer dream, cause you will swear that from the start it was designed to kill artists. Bangakulwela when days are bright, unguthembekile. As a human being on Instagram, ungxekekile. Too much pressure, unrealistic expectations. Whoever said that is the perfect ilizulahlekisile. Is with us, uthembekile. Singiza uthembekile. Remedies within us, ezikrwempa sibhebhekile.